Make sure you tune in or visit and subscribe to Nooganomics.com, the website for Managing Matters here in Chattanooga. There is an astute analysis of the legal ordinance in Chattanooga that's taken effect this week. The short-term vacation rental ordinance, which it displays, if we understand how these faults work and what they look like, we can see them in play elsewhere. As editor and writer, chief journalist at Nooganomics.com, is to explain abuses so that you, my listener, and my reader will yearn for and self-government. Self-government is at the core of the Christian theory, at the core of Christian social theory. More self-government will have less external government. The promise is in Deuteronomy 28 and in many other places, if you obey my law, God says, I will bring prosperity and blessing to you, all kinds of blessings. And if you reject me, if you reject my government, my direct government of you, I will bring upon you hordes of strangers to eat out your substance and to receipts as income, etc., and regulate you at every turn. Serfs and slaves of the king. A lot of self-government in the United States, and concerned about this matter, giving a legal explanation for it, is Brent Allen Winters. Brent Allen Winters is an attorney. He's 62 years old, lives near Terre Haute, Indiana. And many things, mining law, the unincorporated church, he knows a lot about that. He's a litigator, venues, and is a historian and a specialist in the area of common law. What is common law? Common law. Brent, my listener wants to know what this distinction means. We have common law rights in Tennessee. Presumes through its legislation to have totally obviated and made go away the common law by replacing statutes. So, for example, a murder is not a common law offense against God anymore. The state prosecutes a murderer in its own name and is apparently the victim of a murder. So, the defining authority over that. What is the problem? Regimes such as that here in Tennessee?
Well, statutory regimes such as Tennessee, of course, every state's the same. Tennessee is probably less regulated than many states, but
yes, it is.
It puts an inordinate amount of power in the legislation of men, coming from the minds of men, instead of to be observed in the nature of things. And a state legislature ends up saying, "Not." And things are not that are. The Bible says that only God has jurisdiction to call those things which are not as though they are, and vice versa. State legislatures have no authority. They've not been given any authority to do that, but now, of course, they presume to do that. And as time goes on, legislation piles up. Legislators are notorious for passing legislation, but not repealing any legislation. For instance, our Constitution of the United States is a brief of common law government. That's what it is. It doesn't explain anything. It's informant. It's words and it's phrases. It's meaningless. It's nothing more than a disparate. So it's important to understand first that our Constitution of the United States, as the Constitution of the states in most cases, are briefs of common law government. As our Constitution points out, for example, the federal government, there are only 4 kinds of crimes. Only 4 kinds of which our Constitution speaks are treason against the United States, piracies and felonies on the high seas, in the current coin and securities of the United States, and violations of international law. Just 4 categories. But yet, today, and this goes to the power of legislation, it's drunk with the power of to legislate, has on the books now almost 6,000 statutory crimes. We don't know exactly how many. The literature I've read most recently, the studies that have been done, say between 5,500 and 6,000, because they overlap again. Not how many. And there was a book came out not too many years ago average American commits 3 felonies a day according to the statutes that apply to him, state and federal. Federal prisons, just as an example now, approach 300,000 inmates. And every 10 years, it seems like they build another 10 federal prisons. Well, there was no federal prison system. Not until Roosevelt did we get what we call Federal Prisons Industries Incorporated, up in the 1930s. And ever since then, federal prisons and the profit that arises from them, it is a corporation. Again, we're back to that. The building of those prisons has grown exponentially with the beginning. Before that, there were only 4 kinds of crimes 100 years ago, or a little over 100 years ago. Before April 1906, 4 kinds of crimes over which our federal government had jurisdiction. Needed was to jail a few people that needed to be jailed. Barracks and Navy yards, naval prisons, and but now we can't build prisons fast enough to jail people in the United States. Jails more people per capita than any country in the world, including communist China. And it's all because of statutes, myriads of statutes. That's the bad news. Now, the good news is this. In a common law country like ours, where the common law machinery is in place, for example, trial by jury, the right to remain silent, the right to speak, freedom of association, which freedom of religion is a function, and associate with those who believe like you and with the God of your choice. The lawgiver, that is, of your choice. All of those kind of things are here. They're in place. Trial by jury still works. We witnessed the Bundy trial out in Las Vegas recently. And even though the jury was stacked, amazingly resilient institution it is, even though it was stacked, as it most of the time is in federal criminal trials, it still worked. Claims of innocent people. That also happened up in federal court in Oregon, where they were tried just before that. Theory is in place. All we need to do is see the difference, and we're not seeing the difference because it's not taught anymore. Comparative law, which is comparative law is not taught in the law school. Lawyers don't know it. Judges don't know it. They don't see the clarity of the difference. There's only two traditions of religion, law, and government. The world has only ever been 2, never will be more than 2 traditions of religion, law, and government, and those 3 stand all together. There is the law of the land. We call it our common law. Constitution, Article 6 calls it the law of the land, and the law of the city. And everyone in every country is tending either toward the one or the other. I want to bring up a case in point, but I don't want to run over time, or if you have something to say about the difference between common law and civil law and how it would be different in Tennessee. But do I have enough time to continue?
Go ahead. Yes, we're talking with Brent Allen Winters. Go ahead, Brent.
Well, I want to bring up case in point, Louisiana. Louisiana is the only Roman civil law jurisdiction in the United States proclaimed as such. And the civil law, Quebec up in Canada, is the other one in North America. Every other state jurisdiction, provincial jurisdiction in North America, or north of the Rio Grande, I should say, is a common law jurisdiction. Louisiana was settled by the same French people that settled Quebec. Parliament passed what was called the Quebec Act. It's mentioned in our Declaration of 76. Not in name, but in principle. And it says this in our Declaration of 76. The Parliament, the powers that be, have formed a foreign law in a neighboring province with the intention of extending that law into these colonies. Of course, the whole war for separation from Britain was based upon the fact that the lawyers, namely William Blackstone in his commentary, says in the first volume, and this is what everybody in England believed, the common law did not apply in the American colonies. Well, these French people from Quebec, they gave them the canon law of the Church of Rome, is what they gave them, which is a law of the city, the Code of Justinian. The Code of the Roman Empire is the law of the Roman Church. And they gave it to the French-speaking people of Quebec because they were Roman Catholic. I shouldn't say Catholic, that's contradictory. They were Romanists. Well, some of them came to Louisiana. So Louisiana is also a law of the city jurisdiction. There are, well, up until 1968, there were no jury trials in Louisiana because the jury is part of our common law. It doesn't exist in the rest of the world in any way that's meaningful, even if they have a window dressing. But not until 1968, in a And if he said, I didn't get a jury trial, and the Constitution said I'm supposed to get a jury trial. Well, of course, the Constitution applies to the federal government first. Well, it went all the way to the Supreme Court. The Supreme Court said, now, wait a minute. This man may be a citizen of the state of Louisiana, but he's also a citizen of the United States. Therefore, you've got to give him a jury trial. So Louisiana finally, after all the decades of their existence before, capitulated and said, okay, that was 1968. They tried him with a jury. The jury only had 6 members. It's not a true common law jury without 12, by the way. That's a very important number. It's important in the Bible, in the laws of nature of God, written as Blackstone felt. And it's important also the laws of nature as we observe the nature of things. That's why we have the 12-man jury. But now they have a jury trial of 6 persons in Louisiana in capital cases. Capital cases. Don't know that they have one in the other place. That's what Tennessee would be like if it weren't for the law of the land. The law of the land is our common law. The law of the land, that phrase is lifted from back to the Carta. Law of the land. Lex terra. Put in our Constitution, and our Supreme Court has recognized that that was the old phrase that meant due process. What is common law? Due process is a part of our common law. Due process is our common law. Our common law is process-oriented. It is not result-oriented, like the law of the city. The law of the city says we have to reach the result that the state has given us by their statutes. The law of the land says no. We have to follow due process. And if we follow due process, we'll have a good result. That's the maximum of our common law. Bad process, bad result. And of great importance, great note, the laws of nature's God, Blackstone tells us that means the Bible, the written revelation of God, says the same thing. That's why the Bible doesn't stress the result. It stresses the process, the due process. That's why the Bible calls the law of God the way, W-A-Y. That means road in the Hebrew Old Testament. It means road in the Newer Testament, odos in the Greek term. It means a path you get on and you stay on it. Because if the law, if our system, our tradition is not process-oriented, then the ends will just...
Let me ask you a question.
As the Jesuits say in their motto.
Let me ask you a question, Brent Allen. And appreciate what you're saying, but I wanted to get to another point. It seems to me that biblical law and common law are distinct from the other kind in that they look backwards. They look backwards to crimes that have already occurred. How is common law different from the statutory regime in Tennessee?
Oh, you make an important point. Another major difference between the law of the land and the law of the city. And that is that in the statutes are commands. By definition, legislation is command of the sovereign state, or claiming to be sovereign state. And it looks forward. It doesn't look backward. And it looks forward to command the future, to control the future behavior of men, to control the future behavior of their speech. For example, the future behavior of their association. That means contract. To control it, just go on and on and on. That's what legislation does. By definition, our common law tradition looks back. And it focuses on the process in the courts. Legislation isn't the main thing. The jury is the main thing in the common law tradition, and that's why you have that machinery in place. Of course, Tennessee has it. And it looks backwards, and it doesn't say, it says first, it says to the jury, tell us what happened. And even if it's not a jury trial, it says to the judge, judge decides what happened in the past. In other words, it's fact-oriented, not law-oriented. Our common law, we don't have lawsuits in our common law country. We say that it's not true at all. Never has been here. We have fact suits. We don't say to the jury, what's the law? We say to the jury, what's the facts? Tell us what happened. Tell us where it happened. Tell us who done it. Tell us how he did it and why he did it. And the jury does all that. And by the way, once they establish the facts, the law takes care of itself. That's why we give the verdict also to the jury so that they can say, here's how the law applies. And the court, of course, instructs the jury, and the court has a prerogative to do that. But ultimately, we know in our common law tradition, the judge, the court, does not make those decisions, especially in capital cases. The jury decides the verdict. The jury decides the law, too, to the point. But the stress I want to make here is, our common law tradition is a tradition about fact, not about law and scholasticism, and then in logic. That's not what it's about. Where those things prevail, where the theory prevails and the law. That's what the law of the city is all about. It's about theory and about scholasticism. Where that prevails, where logic prevails, facts, says Merriman from both halls, have a way of receiving consideration.
Let me ask you about reform, godly reform of government. There are many Christians who are concerned about reform, and they say that God's law, which is the source of equity, which is summarized in the doctrine of lex talionis, eye for eye, tooth for tooth, is by definition just. Where there's a wrong, the penalty for it or the restitution for it is equal to the wrong, no greater and no less. That's what lex talionis means. It's really kind of equalism. In the future, if we have reform in the future, let's just pretend, Brent Allen Winters of commonlawyer.com, let's pretend that we have a reform that's in a godly direction, in a more constitutional direction. Sketch out what life would be like in a common law society. You don't have a lot of laws, it sounds like, in a common law society, unlike in our time now. So what would it be like living in Chattanooga, let's say, in Southeast Tennessee, if you had a common law reality? How would that be different from what we have now?
Case in point, America is unique above all countries in the world because our beginnings are fact. They're not mysticism and mystery and the legends that we don't know are true like the rest of Europe, for example, and China. We know how our country started. And we know that when people begin to pound their way and hack their way across the wilderness in places like Tennessee, the history of it is very well known. Men like Davy Crockett are very well known. And when they came into the wilderness areas, and Crockett lived in 3-4 counties before he finally settled in West Tennessee over toward the Mississippi River, everywhere he went, there was no organized government. What did men do? Well, they weren't slow in establishing government. And what was the first thing they did? And this is true all over the United States. Most notoriously, when men landed in California in the gold fields, they did the same thing. And we have the records of it. The first thing they established, not legislatures. No, not governors. They established courts. When people had a problem, they say, okay, let's impanel the jury. And David Crockett, his first position that you could call a position of government was to be appointed a judge, called a justice of the peace. And that was the most important thing. In a common law world, the courthouse, the local courthouse becomes an important place, not the state house, not the White House. That's what becomes important. Then people focus locally on the courthouse. And trial by jury is the heartbeat of the common law. It is the soul of our common law. As a matter of fact, the jury is the court of last resort, last resort in a common law country. And even our Constitution says that the fact that established by the jury is not to be questioned in their place. I'm paraphrasing the idea, except according to the rules of the common law. In other words, if the jury arrived at their verdict without due process, then it's questionable, yes. But if due process is followed, the facts of the jury finds in the matter.
Would there be, Brent, let me ask you a question. Brent, would there be driver's licenses? Would there be business licenses in a common law society? Brent Allen Winters.
I don't believe there would if we lived in a pure common law society. But here's the thing that's often missed, and I say this to my patriot friends. The common law is an adversarial tradition. The civil law is an inquisitorial tradition. That means they have inquisitions. They don't have trials. In France and Germany, South America, and China, all the communist countries. There's a Roman civil law jurisdiction. There are no trials. There are inquisitions. You can read about them in the book of Acts. They get rather brutal. Torture is always a part of that. We have trials here. And because we're adversarial, our common law is unknown. And men have said this for centuries, unknown except there's a fight. When there's a fight, our common law becomes known. And the law of the city is constantly trying to encroach in our country. And our common law becomes alive at that point. That's the beauty of it. It's resilient. And it's attacked. And it becomes alive every time I go into court, and every time anybody goes into court, lawyer or non-lawyer, and says, no, I demand trial by jury. I don't move the court for trial by jury in a common law country. You don't do that. You demand it. You say jury demand. Jury trial demand. You put that right on the pleading. Every time we do that, we're fighting back. And every time we do that, the common law becomes entrenched, as the old timers used to say in England. We believe the hand of the common law is still powerful. It is. It's just like we see today. We see that where where men are free to express themselves, the truth wipes out the air. And all that the evil empire can do is now use subversion and deceit. They can't win a fair fight. By the way, David, the phrase fair fight is a common law phrase that comes from common law England. Let the best case, let the best man, let the meritorious case win. Fight me a fair fight. What does that mean? That means due process. Just make sure that everything is done according to the oil, that we fight according to the Queensberry rules, to analogize the whole thing to a boxing match. No hitting below the belt, no sucker punches. Hard blows, yes. Foul blows, no. We're not going to allow that. It is war. Trial by battle. And battle by trial are analogous in our common law tradition, and always have been. And that's why you've got to give notice. It duly is a vestige of our common law tradition. Very important part of the history of Tennessee, by the way. I've read the history of old Andy Jackson. Breaks he got into. By the way, they said that man was so full of lead balls, he rattled like a bag of marbles when he walked. That was the popular saying about Andy Jackson. But not to say that we should have doodles, but to say that we have taken that into the courtroom before the jury, and we fight it out without a fight. There is no, and we, of course, fight according to the rules. We don't hurl bullets and spears now. We hurl oaths. We are oath hurlers, as it used to be said in the common law tradition in the old country across the pond. The most beautiful blessing we have as a practical matter, outside of course, the revelation of the will of God is our common law, but the revelation of the will of God is revealed through our common law procedure, by the way. 2 witnesses required, for example, for treason. All of this, I could go on and on about all of the analogies between the two, but we would live in a world where there were fair fights. Before the jury, by the way, that's our answer to violence. Our courts are open, says our common law. We must go there first. And by the way, when I talked a while ago about the permits to carry guns, our courts are open. Those things need to be tried at the courts, and they need to be challenged. There are so many things that need to be challenged. And our common law said this, David. It said, enemies foreign and enemies domestic. That is the oath of our common law that goes way back and has to do with enemies foreign.
And who are the domestic enemies?
Go ahead, I'm sorry.
Who are the domestic enemies, Brent Allen Winters? You have 10 seconds.
The domestic enemies, to fight domestic enemies is to be willing to serve on the jury. That was one of the 2 duties of the militia. And in our country, the 2 duties of the militia of the several states. 2 duties, serve on this jury, that's enemies domestic. Second duty, foreign or armed defense. That's the second duty of the militia. And those 2 duties comprise the fundamental of government.
This is David Tulis, and we're talking with Brent Allen Winters. Brent, thanks so much for joining us.
Oh, Mike, thank you.
Yes, sir. This is David Tulis. Brent Allen Winters is an attorney. You can find out more about his remarkable analysis at commonlawyer.com. That's commonlawyer.com. And we've been looking at common law and how really it's something that we want to have. David Tulis, thanks for joining us. David Tulis.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.
Don't punish your gun by leaving it in a corner. Shoot it, sell it, or just toss it. Okay. Don't toss it. Make money with it. Shooter Supply and Indoor Range, the hottest gun shop in town, finds buyers for your extra firearms. Put cash in your pocket today. Are ARs cluttering your closet? Rugers rusting in your rec room? Shooter Supply and Indoor Range in Hickson will take your firearm and put it on consignment. To you, that means no money out of your pocket with a small fee when the gun sells. Larry at Shooters has got an online store. He's licensed to ship anywhere. This is if Shooter Supply were giving your billfold cover